On the morning of June 26, 2020, Sarah Keenan was riding her bicycle on a newly opened segment of the Appleway Trail, a multi-use path managed by the City of Spokane Valley. As she approached a city truck parked on the trail by city worker Peter Fisch, she slowed down to allow pedestrians to pass. As she attempted to go around the truck, she suddenly crashed, suffering a broken leg and knee injuries. Keenan later saw construction debris on the trail, including a plastic lid and possibly black tubing, which someone suggested she had hit. There's no indication she saw the debris before the fall, and Fisch did not witness the incident. However, he confirmed there was leftover debris on the trail, including wood, tubing, and a plastic container, as he had been tasked with cleaning up after construction. At the time, there were no signs warning of hazards or indicating that the trail was closed and others were using the trail. The Appleway Trail is a non-motorized recreational path maintained by the city under a 2012 interlocal agreement with Spokane County. The city is responsible for building, maintaining, and operating the trail and has accepted liability for any claims arising from those duties. The trail is zoned for parks and recreation and considered a recreational asset in the city's comprehensive plan. After being injured on her bike, Sarah Keenan and her husband sued for damages. The city moved for summary judgment, asserting application of Washington's Recreational Immunity Statute. The trial court granted the city's motion and dismissed the case. Now the couple is appealing. Let's take a look.
Thank you, Your Honor. Again, my name is Richard Iman. Mr. Huntington with the Washington Association of Justices is with me. In my brief time, I'd like to address the issue of the latent condition that existed on the trail at the time of Sarah Keenan's bicycle accident. This was in June 26, 2020. There's two issues, okay? One is whether the scope of the recreational immunity statute applies to the facts of this case, and that's something Mr. Huntington will be handled. Even if it does apply, was the injury-causing condition a known, artificial, dangerous, and latent condition? Okay, so under either issue, okay, there's questions of fact, okay, and that essentially we're asking this court to reverse this particular decision and return it to the Superior Court for further proceedings.
Does Ms. Keenan argue that the truck distracted her from seeing the pipe on the trail?
Yes.
Is the truck a separate condition from the pipe for purposes of immunity under the statute?
A separate, the truck existed on the trail. The defense claims it had flashing lights on, which was obviously a distraction to her, as well as a couple that was coming the opposite direction.
So when we review the condition, as that word is used in the statute, do we include not just the instrumentality that directly caused the accident, or do we also include in it circumstances surrounding that particular instrumentality?
Under the Schwartz case, you would. Okay, in the Schwartz case, obviously, it was
what?
It was atmospheric conditions in the Schwartz case that led to, obviously, the expert testimony here. The facts stand alone without expert testimony. She was injured, as we said, as she was approaching the truck, and obviously, as we argued, that she was distracted.
Mr. Iman, wasn't one of the cases, it wasn't Schwartz, I'm forgetting which one it was. There was another case where a city vehicle gave off a plume of smoke while the bicycler was passing by and caused the bicycler to crash into another bicycler, and that was the claim of negligence. Do you recall which case that was? I forget whether
I do.
it might have been
Lochner.
Lochner. Is that the facts in Lochner? Okay.
Okay, in the Lochner case, obviously, Mr. Huntington will address the Lochner case along with the other cases in that particular area.
Well, but I think Judge Pinnell's getting to why didn't the court in that case take into consideration the circumstance of the wind blowing and the dust blowing from the motorcycle, or the lawnmower, I should say.
They probably should have. Okay, so
it was error.
yes.
Okay. Did Carl Schwartz win or defeat the summary judgment motion only because he had expert testimony?
expert testimony helped in that particular case, obviously. They had a situation in which there were atmospheric conditions that led to the inability of the bicycle rider before he approached the bollard to recognize that it was there. Okay, here obviously we have different facts in this particular case. And utilizing the Schwartz, okay, what the Schwartz case did obviously is and I'm not probably telling you something you don't know, decided the standing by test is not what the law should be, okay? And that goes back to the restatement of torts 343B, okay, which clearly states that a possessor of land is subject to liability for physical harm caused by his invitees by a condition on the land, but only if he should expect that they will not discover or realize the danger or will fail to protect themselves against it and fails to exercise reasonable care to protect them against it.
Mr. Iman, I want to redirect you a little bit before your time is up. I think one of the city's arguments are there aren't facts that Ms. Keenan was injured by the pipe, that she was injured by this garbage can lid or a lid to a container. She didn't see what she was injured by, and this garbage can lid would have been non-latent. How do you respond to that?
That the evidence really doesn't get us to whether it was a pipe or it was other debris. We know that
You've got the burden of proof. Is that a problem?
No, it's not, because there was debris on the road. The defendants in this case have admitted there was debris, but it's obviously when it comes to her perception, okay, the evidence is that when she was laying on the ground, someone told her that there was a black pipe, okay, on the road. But
is that admissible, what someone told her? Or has that just not been
it probably doesn't
fleshed out
make any
yet?
difference as long as the city admitted that there was debris on the trail, okay, and she hit something, okay, which caused her to essentially...
It doesn't matter what the debris is, because looking at the photos, I mean, the pipe is hard for me to see, and I know that I'm looking for it. And whereas if I were a bicycler, I wouldn't be knowing that I'm looking for a black pipe. But there's not a photo of this garbage can lid. It seems like there'd be a stronger argument that the garbage can lid, or whatever it was, would have been visible.
Well, the way I answer that is there's material facts that need to be go to a jury in this particular case to figure out the answers to that particular question. If you're going to meet the rule that's been set forth by Schwartz, this case obviously should go back to the jury in that regard on those particular facts. Okay.
Mr. Iman, I think you're well into...
Before any discovery happened in the case, the city moved. So we're only working off evidence that was produced by the defendant in this particular case, which shows there was debris, that she was distracted, and the rule that someone standing nearby, okay, could see these debris is not the rule anymore. Jules' case is overruled simply, and
You're well into Mr. Huntington's time. You're free to continue, but it's going to be taken from Mr. Huntington.
thank you.
Thank you. Mr. Huntington?
Thank you. May it please the court, I'm Dan Huntington, appearing on behalf of Amicus Washington State Association for Justice Foundation. With me on the brief and also present in court today is Valerie McComey. And as Mr. Iman indicated, I am going to address the issue with respect to the scope of the recreational use statute, and in particular, its application in a case where there are disputed issues of fact as to whether a trail was intended for recreational use or whether it was intended for transportation purposes.
Mr. Huntington,
Yes.
was the trail opened for recreational use at all?
That fact should be determined by the trier of fact. I believe the evidence shows it was open for incidental recreational use.
Well, that's a confusing word. I think that, like in the Camasia case, as refined by Lochner, and I'll give it to you that Camasia, if you just were to read Camasia, it'd be very confusing. But in Lochner, there was a deed that says this trail is to be opened only for transportation, some words to that effect. And because of that, the Lochner court says there's material issues of fact as to whether or not this trail was solely open for the purpose of transportation, and therefore there was no recreational purpose by the landowner. Clearly there was recreational use, but that was merely incidental, not a purpose. So as I interpret it, the word incidental is not a purpose. So was the Appleway Trail open for recreational use? It might have been the third or fourth most important use, but it was nevertheless open for recreational use. Or are there facts to say, no, the only purpose, like there was in Camacia, there's some document somewhere saying the only purpose of this is transportation or some other non-recreational use. Therefore, there's an issue of fact.
Now, Your Honor, the court in Camacia said that if the trail is open for other public uses and only incidental recreational use, then immunity doesn't apply.
But again, refined by Lochner, which is a later case, said, look, Camacia, the only reason why we said there was issues of fact is there was some facts, and it's kind of weird, because there were certainly some facts to say it was a mixed use, which says it's a jury question that, you know, it's not in favor of the plaintiffs. But there was some facts, if perhaps a jury believed, that the only purpose of the landowner was non-recreational. And if that's the case, then there's obviously recreational use, but that was never the purpose of opening it.
In Lochner, the court also addressed the statement in Camacia regarding incidental use. At page 529, 190 Washington 2nd, 529, the court in Lochner said, while more than incidental recreational use may be required, sole recreational use is not required before conferring immunity to landowners.
And I guess what we're having a debate over here is the word incidental. I don't see the word incidental to mean purposeful. It means I'm opening my land solely for transportation purposes. And as it's incidental that some people happen to recreate on it, I'm not kicking them out, but that's my purpose. And what's interesting to me is the statute refers to hydroelectric power plants that can be immune. Clearly the primary purpose, probably 90%, 95% of the purpose of a hydroelectric plant is not recreation. But if it's nevertheless a purpose, not merely incidental, that they're not kicking people off as trespassers, but they're opening it up to recreational use, then immunity applies. Why isn't there that distinction?
Well, and that's a question for the trier of fact. Is the recreational use more than incidental? If it is, the statute may apply.
I guess I'm not seeing that I'm seeing it needs to be opened. And something can be incidental. I mean, it could be that the most common use of a trail is recreational, but that was not the purpose at all. The purpose was solely transportation, but it just so happens that pedestrians have taken it over. But there's never been a recreational purpose. Meanwhile, what we're looking at is the landowner's purpose, not how people use it.
And here, in looking at the landowner's purpose, a crucial piece of evidence is the city's application for funding for this trail. The city representative answered a questionnaire. The application itself said, this program is for transportation projects.
Did they ever say transportation only? Because that same application also said another benefit is recreation.
It did, and the question is that an incidental use or is it something more? And that's a question for the trier of fact. That application is replete with statements from the city saying the intent of that trail was for transportation, intermodal transportation purposes. The primary purpose of that trail was to get traffic, pedestrian and bicycle traffic off of Sprague Avenue and onto the trail. That's what the city said in that application. Now, they commented, I think they started the phrase with, however, there is some other recreational benefit to the trail.
So
that could be an incidental use.
Before you finish, I'm going to quote from you from Lochner, which said that critical to the holding in Camacia was a deed that specifically provided the trail could be used for road, street purposes only. And so that was identified in Lochner as the critical reason why summary judgment was not applicable in Camacia. There was evidence of only having one purpose. Is there similar evidence here of only having one purpose?
There isn't evidence of one purpose. There's disputed evidence as
Well,
to
no,
whether
no.
it was
But there needs to be-
transportation.
In order to have an issue of fact for trial, there has to be evidence from which a jury could find there was just one purpose for this trail, and there's not.
No, I don't agree with you. That's
Okay.
why I'm shaking my head. I'm not saying there's
Okay,
not.
I'm just reading from this case.
Well, Lochner has to be considered in the context of the procedural nature of that case. That case was reversed by the Supreme Court, or that case held that summary judgment should have been granted because the plaintiff argued, and the Court of Appeals agreed with the plaintiff, that the property owner had the burden to prove the sole use of the property was recreational. And the plaintiff in that case was wrong. Kamisha didn't say that. And all that the Supreme Court did in Lochner was say, summary judgment should have been granted here because the plaintiff's only argument was the burden was to show sole recreational use, and that is not the law. That's what Lochner held. It did not disagree with Kamisha. There's no problem with trying to reconcile Lochner and Kamisha.
Okay, I think your time is,
Well, I have a lot of questions for you. Were you planning to do the rebuttal for Ms. Keenan?
I will now if...
Okay, let's pretend you're planning to do the rebuttal, so we'll have you sit down now. Even though your entire time is done, I'm gonna allow you to have rebuttal because I think Judge Pinnell and I have some more questions for you.
Thank you, Your
So,
Honor.
Ms. Clark?
Thank you, Your Honors. Good morning. Megan Clark here on behalf of the City of Spokane Valley, and I know I have 15 minutes. I'll ask the court if you have a preference of which issue I begin with the recreational use or the latency. Any preference? No?
Apparently none.
Okay. Well, I will start going with Mr. Huntington's argument first with respect to the recreational immunity. And I want to answer a couple of the court's questions that were brought up. We do have to look at Kamisha with respect to the Lochner case. And what those cases say is exactly what Judge Pinnell was saying, is that sole recreational use isn't required in order for recreational immunity to apply.
didn't they go further than that? I mean, they talked about the McCarver case and said, we're not looking at primary or secondary. We're just looking at, was the property open for recreational use, full stop?
That's correct, Your Honor,
Full
they do.
stop.
And that's what the trial court in this case ruled. The judge said in that case that there was recreational use of this trail. And I'll quote from Lochner at page 534, which says, in light of the plain language of the statute, immunity is not extinguished when the land is used for other public or private activities in addition to recreation.
Well, I'm going to correct you because I think we get a little bit sloppy. It doesn't matter how the land is used. That's a separate issue. We're talking about the landowner's purpose in opening. And so something could be used contrary to the landowner's purpose maybe, and the landowner's not kicking people off of it. But we're talking about, for example, in the Kamisha case, it was irrelevant whether the person was recreating or driving to work. What mattered was the landowner's purpose. So I just think it's important that when we're talking about this component of the recreational use immunity statute, we're talking about the landowner's purpose in opening, not how the property was, what use they were opening it for, not how it was used.
And that's from the Lochner case. That is that objective standpoint of the landowner. Whether the land has been open for recreation is to be viewed from that objective standpoint. And at the trial court level, the City of Spokane Valley provided its objective evidence of how it uses this trail and how it treats it. And I will say there is a section of the statute that says allows the public to use the property for the purposes of outdoor recreation. So there is some analysis of the current and present use in addition to the opening of the trail and what it was open for. And in this case, we go all the way back to 2012 and we look at the interlocal agreement that existed between the county and the City of Spokane Valley. And that interlocal agreement transferred the railroad property primarily for the use of a recreational trail, stating that the county has the ability to operate, maintain parks, playgrounds, bicycle paths, and other recreational areas. And they may transfer such property in order to utilize the property for that purpose.
I think what Mr. Huntington would say in response to this, I don't want to speak for him necessarily, but he would say, well, that's why you have an issue of fact. He's saying that there's this other document that says non-recreational use. So I don't think anyone's saying that there's not at least issues of fact as to whether or not it was open for recreational use. What the question is the city entitled to summary judgment because there's no argument that it wasn't open for recreational use?
And Your Honor, I would respond to that in saying that the only evidence that the plaintiffs have ever produced in this case to support a theory that this trail was opened primarily or for the intent to be used as a transportation corridor is a funding document that was submitted to a transportation agency who distributes funding throughout the region for projects of varying scopes and sizes to various agencies. That document, if you read it in full, and I know that the court has, doesn't just talk about transportation uses, but it answers the questions of the application. And in that, the only transportation use that is highlighted is really safety related, to say, we have Sprague Avenue, we need to get this non-motorized traffic off Sprague Avenue for their safety. And is that a transportation use? I suppose, because it assists people not getting injured by cars or buses on the road.
That was a question I have for you. It's very interesting.
So,
let's say everybody on Sprague Avenue that rides a bicycle and everybody that walks on Sprague Avenue, none of them are commuters. They're just having fun and recreating, but they're causing a danger to trucks and cars. And so to give them a trail where they can recreate, but you're doing it for transportation purposes, boy, it just gets confusing thinking what's the transportation or recreation purpose?
It does. I don't disagree with you, but the transportation is the incidental piece, not the recreating. And that's a trail. When we think about a trail is recreational. You're hiking, you're walking. It's 12 feet wide in many spots on this trail. And Camesia says we don't just look at the portion of the trail where the person was injured. We look at the entirety of it. And that's from the Camesia case. So we look at the entirety of the trail. It's 12 feet wide in some places. Places for people to go with their families and strollers. There's benches to sit. There's park amenities. There's certain specific lighting. We have, if you look at the document that they point out, this congestion mitigation air quality application, we have that one transportation use, and I'll put it in quotes because I think it's actually more safety related, which is to get that traffic off of Sprague Avenue. And we look at the recreational uses that they point out. A 12-foot wide shared youth path, trail amenities, a 6.2 mile long trail, a place to hold community events, allowing people to congregate, linking to the Centennial Trail, increasing bikes and walking trips for pedestrians. During winter, allowing it to be used for cross-country skiing, providing a greenway trail that contributes to the quality of life, supporting exercise and other benefits. That's at clerk's pages 101 to 102 and 106. That's their document that they're pointing at, saying this is transportation. There is significant recreational discussion in there. And if you read the sentence about transportation related, it's the same sentence over and over and over. Get this traffic off Sprague Avenue.
But if people are walking, let's say people are, what the purpose is, we want to encourage people to not drive cars to work or to shop. We want people to walk or use non-motorized modes of transportation, and we need to provide a safe place. Isn't that a transportation purpose?
I don't think it's solely transportation. No, I don't. I think there are incidental transportation benefits because you have less cars on the road, and you have environmental considerations that come up that are incidental to that. It helps the air mitigation, which is part of that program. You have commercial and economic benefits to a city and a jurisdiction that say, okay, great, we can connect these residences to their jobs or to a commercial center. But moving transportation, the definition is to move people or goods from one place to another. I think when you look at the Camesia case and what they were looking in that case as a transportation is there was not just the factor of the deed, as Your Honor pointed out, which the deed was a large factor in Camesia of that limiting instruction from that restrictive covenant in the deed that says you can only use this for road purposes. The WSDOT had found that. WSDOT was the prior owner of that trail and said, we think this is primarily transportational. They have the deed when they transfer it over to the city saying you can't use this for anything other than road purposes. And they also noted that it was the only spot where you could get from across Lake Washington over to Mercer Island. It was the only spot you could utilize. Now, that none of those things exist in this case. And when we look at the Lochner case, this is much more similar factually to what occurred in Lochner. And I know I'm running short on time with respect to latency. There's only 6 minutes left, but I want to leave the court with this. It's an objective viewpoint of the landowner's standpoint. And the City of Spokane Valley provided evidence that was effectively undisputed. The only dispute was this application that's been provided, and that does not rise to a genuine dispute of material fact for summary judgment. And the Superior Court was correct in saying that, viewing this from the objective standpoint of the landowner, it was open for recreational purposes, and it did have transportation benefits, but that does not convert this trail into a corridor.
I hear you saying that it wasn't open, it was primarily for recreational purposes, so that's why you win.
I don't know
If
that
it was
it has to be.
okay, I don't know that it has to be, but I hear you saying that, so that's what perks my ears up. If this was primarily for transportation, but it was open for recreation, and there's no evidence that that it was solely for transportation, is that good enough?
That's the Kamicia case. That says you don't have to have the sole use, but in that case, it was determined that
There
it was
was facts
open
in-
for transportation, and it was incidental.
I mean, maybe I'm
recreational.
misunderstanding this. I thought, given the spin Lochner put on it, that Kamicia said, look, there's facts from which a jury could find that this was solely for transportation purposes, that it was opened. Now, use is different than why it was opened, but there's facts from which a jury could find it was never opened with a purpose for recreation. But as long as but if there isn't that kind of evidence of exclusivity or non-recreational purpose, then it's not a jury question, because it doesn't matter how much. See McCarver.
And the Lochner case does talk about use and how it is used. It isn't just back at the original intent. We don't go kind of to the original intent exclusively.
No, you continued
look-
intent.
Correct, and that's why the evidence that we provided shows not only the original intent between that interlocal agreement and some of the initial
But
documents.
she was injured the first
yes.
day it was opened. So-
Pardon me?
She was injured the first day that it was opened.
Not
right?
the first day, but the first week.
Okay.
Yes. So I do want to use the rest of my time to talk about the latency.
I'm gonna prevent you from doing that.
Okay.
And we'll likely go over time, and we'll allow the Keenans additional time. Judge Pinnell, do you have some follow-up questions
No,
before I?
not right now.
Okay. I want to read to you, Ms. Clark, pages 113 through 115 of the record, which is the application to the federal government for funds. Before doing that, I believe you commented that in the Kamicia case, WashDOT said that the trail was primarily for transportation purposes, and you thought that was significant. Is that correct?
That was one of the factors that the court
Said
determined.
raises an issue of fact.
One of the factors that the court discussed, yes.
Okay, on page 113, the government asked, please describe how or why the project relates to the transportation system. City answers, then reads further, projects must be primarily for transportation purposes rather than recreational purposes. Projects lacking a functional proximity or impact linkage to the transportation system are not eligible. City answers, the proposed project promotes non-motorist modes of traffic and improves safety for bike and pedestrian traffic through the commercial core of Spokane Valley. Goes on to read, the trail accesses services such as healthcare, banking, postal and governmental services, retail services, employers such as Numerica, Monaco, H&H Molds, and various retail services will allow walkers and bikers to access jobs. Does that indicate that the city is representing, for purposes of getting funding, that this is primarily for recreational purposes?
Your Honor, I think it goes back to the question of this kind of mixed use. And a trail doesn't lose its recreational status because there are other benefits. And the benefits that Your Honor just read are commercial, economic development that certainly exists as an incidental benefit.
Well, to me, this is just as if it's Sprague Avenue. It's just a little safer for those on the bikes.
I don't know that I agree with that characterization, Your Honor. It is a trail that has features, that has, it has bollards up in some places to keep vehicles and cars off of it. It's wide, it's available for not only bicyclists. And the recreational immunity statute doesn't just talk about bicyclists, it talks all kinds of different recreational uses that exist here. Picnicking, bicycling, skateboarding, non-motorized wheel-based activities, all of those things can get you from your house to your job. And that doesn't convert the status of the trail to a transportation corridor and losing its recreational status. I don't think that that application is dispositive in this case.
On June 26, 2020, was the path open to the public?
Yes, Your Honor.
Had there been a formal announcement that it's open to the public?
I do not know if that is in the record. I believe there was a ribbon cutting, but I don't know when it was. And I don't know that that's in the record.
Because I'm curious why they're still cleaning things up if it's been open.
They were just completing some punch list items, and Mr. Fisch filed a declaration that's in the record. And he was indicating that he was there cleaning up a swale that was adjacent to this section of the trail. And there was a fence up, and he was taking debris and putting it on the other side so he didn't have to walk all the way around. Had his truck in the middle of the trail with his lights flashing. All of those are undisputed facts. And what was in, and this is sort of getting to that latency argument, I guess, but what was in the trail was it wasn't a garbage can lid, it was a white plastic bin lid with some soft tubing. It's unknown what Miss Keenan, what caused her accident. That wasn't any part of the summary judgment, and there was no request to continue for more discovery. So we had the summary judgment hearing, and it was assumed for the purposes of summary judgment that she hit something, but it's unknown if she hit anything or if she just crashed. So
does the city contend that there's a difference as to whether or not she hit a pipe or a lid?
No, all of the debris, I'll call it, well, I guess I'll go back. We look at what Ms. Keenan said, and what Ms. Keenan alleged in her complaint was that there was a black pipe or other debris. We've provided, the photographs of the trail that day were provided to the trial court on summary judgment, showing the exact condition of the road when
Okay.
she crashed.
Let me get back to the initial part of the case about opening for recreational purposes. Kamika and Lochner specifically uses the phrase opening the land to members of the public. When you go to RCW 4, 24210, it doesn't anywhere have the word open or opening. It says statute refers to allowing members of the public to use the land for recreation. Is there a difference between those two concepts?
I don't think so. I think they can be harmoniously looked at together. But the use, the continued use, I think, is more persuasive than the original intent.
Well, to me, opening means the initial intent, and allowing members of the public means an ongoing intent.
I agree.
Okay, and which is controlling here?
Well, that's why I said when you look at the case law, and the case law it does talk about the continued use. It's both. So I don't know that either one is necessarily dispositive, but if you look at how the trail was opened, but the continued use of it.
Isn't it the continued purpose,
And
not the continued use? Because the cases look at statements made in deeds, statements made on websites to determine the landowner's purpose. It doesn't look at, this was open to the public for recreational purposes because people were recreating. That's not the standard, but I hear you saying that.
No, and I want to clarify, I don't want to be unclear about my position. The city provided such statements and
I know you
provided
did.
such
It's just
information,
when I
and
hear
that
you-
is the position, is that it is what is objective from the landowner's perspective.
Or what they
how
opened it
is
for or allowed it to be used for.
Both, yes.
Any other questions for Ms. Clark on the issue of recreational purposes? Okay, I'll give you now 2 minutes on the latent condition.
Thank you, Your Honor.
issue.
I
And
appreciate
I'm wondering, does Schwartz overrule and get rid of the standing in front of the condition test?
It abrogates that test, yes, that's correct. But the trial court in this case didn't rely on that test, and you can look at the verbatim report of proceedings, what the court said, and it is that that's at the VROP at page 42, which the trial court said, and Schwartz tells us to do an analysis of what the general class of recreational users would view this as, and referring to the condition. And when I do an objective analysis, this was not latent. The condition was clearly observable. And there's a reason we need to apply an objective analysis, because different people are going to have different perceptions and be in different states of mind.
But can't there be an issue of fact? I mean, all respect to the trial judge, when I look at it, maybe my eyesight's not as good as hers, but I have a hard time seeing it. I saw the photos in Schwartz. They were in the dissenting opinion at the Court of Appeals. I can see that bollard, at least from the photos. I understand there was expert testimony to explain why it wouldn't have been visible, but I think that that's a much closer case than this one if it was the pipe. Again, I can see that it's a pipe if you tell me that it's a pipe. I'm not convinced that if I didn't know ahead of time that that was a pipe in the middle of the road, that it wouldn't have just been a shadow.
And again, the debris that was in the road, there was a couple of soft tubings. They're not pipes.
But we don't know,
But-
viewing the evidence in the light most favorable to
You
her,
are.
it could have been that pipe.
Sure. And
Coupled with being distracted by these lights, and if the Lochner case said you can be distracted by a plume of exhaust smoke, why can't she also be distracted by the lights?
well, the Lochner case does say to look at the conditions also surrounding this. And I want to point the court to the Ravenscroft case, because it does go through a litany of other cases where the court talks about latency. And I pointed those cases out to the trial court, the Van Dintner case, Widman, Chamberlain. Those cases talk about conditions that were much more observable, much less observable than the conditions here. But it's not a subjective test. We don't look at this subjectively. It is
But
an
it's still
objective.
a jury question, whether a jury should decide whether objectively this was observable or not.
Well, it can be decided as a matter of law that it was not latent, it was obvious. And that is what we argued to the trial court, and it's what is not readily apparent to the recreational user. And the court looked at the photographs, the court looked at this from that objective standpoint. And we aren't looking at this standing near test. Wasn't what the trial court relied on to make this decision, so that's not any reason to overturn her decision. But we look at the Schwartz case, which is what is heavily relied upon. And in that case, the experts in that created an issue of fact by saying, we as independent experts have analyzed this and have provided information to the court that says, and I don't want to misquote it, that the contrast between the bollard and the pavement of the trails shifted dramatically on overcast days. In a period of about 2 minutes, the appearance of the bollard went from being dark against a lighter background through zero contrast and being light against a dark background. And they testified that it was not readily apparent to a normal observer. That doesn't exist here.
Was the bollard in Schwartz more obvious than the pipe and or the lid in this case?
Not according to the experts that
Well, the
provided
experts
testimony.
didn't have the Keenan case in front of them. They couldn't compare the two cases.
And if we look at this case, and if you look at the photographs, there's on the trail, it's a bright sunny June day. There's no other, it doesn't appear that there's anyone around, although there's some indication there were 2 pedestrians walking. But it's clear. You can see in the photographs the debris, and it's not next to it. There are several different photographs taken from several different angles and locations, and you can clearly see in the photographs the debris that is in the road. And it's not germane to say, what did Miss Keenan see that day? That is not what we ask.
That's not, I mean, but it is whether or not a jury could find, just like we have reasonable person standards, you know, would a reasonable person have seen this? And are there issues of fact as to that? I mean, the fact that you can see it, and I'm also very concerned that hindsight is 20/20 literally in this case, when we know what we're looking for, whereas we have to assume the position of someone who doesn't know what's in the road ahead of them. And could a jury find that an objective person would not have recognized it as being an obstruction, particularly given that these lights were flashing well above it? And so that's where the eye was directed to, the lights of the truck, when on below there's this small black pipe the same color as the trail.
And Your Honor, I don't believe it's in the record that Miss Keenan stated she was distracted by the truck.
Well, I mean,
don't know
there's
that
not
that's
a lot
in
of
the
facts,
record.
but we view the facts in the light most favorable to her, and I think that what she said was she was trying to maneuver around the truck. We know the truck had lights on at the time. And so given those circumstances, is there a question of fact? Maybe you win, maybe this is a winner jury argument for you, but is there a question of fact of whether or not a reasonable recreator would have seen that black pipe the same color as the trail?
And it's the city's position that there isn't one.
That no reasonable person would have failed to notice it.
That there's no question of fact, that the facts were provided to the court, and the court did an objective analysis, the trial court correctly, and we are asking that you affirm that decision.
Okay, thank you, Ms. Clark. Any other questions for Ms. Clark? Thank you. Mr. Huntington, if you would please return. Judge Pinnell, do you have any more questions for Mr. Huntington? Mr. Huntington, where do we discern whether the land was open for recreational purposes? Where do we go? Do we go to some records?
Your Honor, you go to the evidence that was presented on summary judgment, and you were quoting from what the piece of evidence that shows from the viewpoint of the plaintiff that this was open for transportation purposes. You quoted from CP 113. On the next page, CP 114, this is a statement that was prepared by the authorized representative of the City of Spokane Valley. Quote, "The intent of this trail," and this is again CP 114, open quote, "The intent of this trail is to provide multimodal transportation options to those who live and or work in Spokane Valley. The trail will provide citizens the option to use other modes of transportation. This enhances accessibility and connections among city centers, regional service centers, and attractions, towns, and areas of regional employment." That was the purpose for this trail, as stated by the authorized representative of the city.
Okay, let me read to you page 121, also from the application. "Another benefit of this project is it gives people of all ages the opportunity to use the Greenway Trail for health promoting transportation options and family recreation." Does that defeat your opposition to the summary judgment motion?
It does not defeat it, Your Honor, and with all due respect, I want to add the first word to
However, okay.
That, I mean, this is almost a script for what Kamisha said with respect to incidental recreational use is not enough to bring on the immunity of the statute. Here, we have a trail open for transportation purposes. However, there also is an incidental recreational benefit. That's not enough, according to Kamisha. And in this case, given that all of this evidence about the purposes for the trail, This is a question of material fact for the finder of fact.
Is
It
there-
shouldn't have been resolved on summary judgment.
Is there any evidence that recreational use was not a purpose, however minor? Is there any evidence, like, I know that you disagree with me on Kamisha, but is there any evidence that recreational use was merely incidental but was never a purpose? Is there any evidence
I
to that?
think what I've just been reading is
Okay, but
evidence that
can-
it was an incidental use.
So that's evidence of sole purpose, that there's just one purpose, transportation, and our purpose is not recreation, but is incidental to this transportation purpose. Is that
It's-
what,
It's evidence that the purpose is transportation. There's an incidental use for recreation.
is that a purpose for recreation, minor, or is it we don't have a purpose for recreation, but we recognize that recreation will happen?
It's a recognition that there will be recreational use.
But it's not opening it with a purpose. It's saying
No.
we're only opening. So when we're saying this, they didn't use the word only, but you're interpreting this to mean only.
In the words of the representative of the city, the intent was to open it for transportation
But they didn't say the
purposes.
word only.
It didn't say the
Okay.
word only. And I want to just close with a brief quote from.
Before you
Kamisha.
close,
Yes.
do you want to address the distinction that I made with Ms. Clark between the Kanika and Lochner language of opening the land from the statutory language of allowing use of the land?
Your Honor, I don't know in this case the significance of that, and I really don't know the answer. It just seems to me like this idea of is it available for recreational use shouldn't be determined simply at the time of opening the property. If that was true, then what if property was open for one purpose, but over the years, the intent was to use it for a different purpose? Should that be foreclosed from immunity just because it wasn't originally used for recreational uses? I'm not gonna go so far as to say that. So I think it's an open question as to whether, under the statutory language, allowing it for recreational use is limited to the opening purpose or can change over time.
Okay, any other questions for Mr. Huntington?
Well, I'm just wondering with the allowing, almost seems like we won't deem you a trespasser. If we are only going by the statutory language and we were writing it anew, it would be, well, we're not gonna kick you off because you're recreating, we're allowing you, but it's not our purpose at all. It seems like the way it's been constructed with the word opening instead of allowing being the word that the courts have used helps you more. I mean, if it's just that you're allowing recreation means we're not gonna consider you a trespasser, but that's not our purpose.
Well, and I'll remind the court, Lochner said, this statute doesn't answer this question about in the event of multi-purposes, in the event property is used for multiple purposes, what the impact on the immunity is. Lochner says the statute doesn't
Well, that
answer
just
that.
goes to the element of whether or not it's been opened to the public, not what the purpose is. That's what I understand that. Do you understand that as being the same? It goes to the element of, you have to prove that the land was open to the public and that it was open for recreational purposes. That footnote talked about whether or not it was open to the public, whether or not you had the power to close it or not, determines whether or not you're really the landowner with the power.
Well, I think it
Follow
was
the
broad.
statute.
I think it's broader than that. I think the court's saying we don't have an answer to the question here when property is open for multiple uses. The statute doesn't answer that, what the impact is on immunity. My closing.
Mr. Huntington, any other questions? Okay, I'll give you a minute for closing. You can also address the latency issue in your closing too.
Okay, my closing comment on the scope of the statute comes from a brief quote I'm gonna read from Kamisha, 179 Washington 2nd at 699. Extending the reach of RCW 424.210 to land that is open to the public for purposes other than recreation simply because some recreational use occurs not only undermines the statute's plain language and the legislature's intent, but would also unjustly relieve the government of its common law duty to maintain roadways in a condition reasonably safe for ordinary travel. Now, with respect to the latency issue, Your Honor, as Mr. Iman mentioned, in Schwartz, the testimony of the experts that the court applied to hold that this condition wasn't subject to immunity included not only the bollard, but the atmospheric conditions, the twilight, the fog, all of that were the conditions that they considered consisted of all of that. Similarly here, it's not just the injury-causing element, whatever the debris was that Ms. Keenan ran into. It is the rest of the conditions, the truck being parked on the trail, the pedestrians flowing around it, the flashing lights, all these things that could distract a recreational bicycle user from seeing the debris on the trail.
And your time has expired. Thank you, Mr. Huntington. Thank you, counsel.
Following these arguments, the court affirmed in part and reversed in part. The order is affirmed as to the affirmative defense of recreational immunity, but the order is reversed as to whether the Keenans can establish an exception to immunity based on latent defect. The court remanded for further proceedings.